Welcome to Workplace Wake Up, your go-to podcast for practical employment law guidance. I'm Jennifer Shaw, the founder of Shaw Law Group, and I'm here to help HR professionals and leaders navigate the legal minefields of the modern workplace. Each week, we tackle real-world issues with clear advice and a little tough love. Let's get started. Welcome to the podcast, and happy holidays again. I know many of you will be celebrating today and having parties and eating great food, and I hope you all just have an amazing day. So we're going to be talking about layoffs, okay? Not a very fun topic, unfortunately, but an important one, because even when the economy is good and the company's doing well, sometimes you have to do restructuring. We did a little bit of that earlier this year, just to kind of right-size the organization and make sure that we had the right positions in the firm. So this stuff sometimes just needs to be done. Okay, so we're going to talk about layoffs. And there are two laws. Well, there's one law that I want you to be really familiar with, and then I'll tell you how it relates. Okay, so we're going to talk about SB 617. Now, SB 617 is a new law effective January 1, 2026 that applies to what we call California's Worker Adjustment and Retraining Notification Act, fondly referred to as Cal-WARN, okay? Now, I want you to remember there is also a federal WARN Act, okay? And the federal WARN Act has some requirements that are a little bit different than Cal-WARN, okay? So as a reminder, Cal-WARN is located in the Labor Code. It begins at Section 1400. It goes through Section 1408, and it requires covered employers to give 60 days written notice before you take certain actions. Okay, so first of all, who's covered by Cal-WARN? If you have 75 or more full and part-time employees in the preceding 12 months. That's the preceding 12 months before you take the action, okay? Now, what are the actions? So 75 is the magic number in California. 100 is the magic number under federal law. And there are other states that have what we call mini warns or baby warns, just like California. Now, Cal-WARN is triggered by three events, okay? The first one is what's called a mass layoff. That is when you lay off 50 or more employees within a 30-day period at what we call a covered establishment. So this is a single location, okay? The second triggering event is what we call a relocation. This is where you move all or substantially all of your operations more than 100 miles away. The third triggering event is termination. This is where you are closing or ceasing all or substantially all of your business at a covered establishment or a covered site, okay? So when any of these things happen, you have to give notice to four different groups of folks: to the employees who are affected, and if you're a union shop, also to their representatives, to the Employment Development Department. Okay, that is the agency that administers unemployment insurance, state disability, paid family leave. You've got to tell them because they will come in and try to help those folks get new jobs. The local workforce development board, that is a board that is located in each county to help evaluate workplace trends, bring new employers into the area, that sort of thing. And then the chief elected official of the local city and county government. So these are the four groups of people who you have to give notice to. Now, when do you have to give the notice? At least 60 days before the triggering event. Remember, that's going to be the mass layoff, the relocation, or the termination. And there are a number of details you have to put in your notice. Now, if you don't do this correctly on time and include the right information, you are going to be required to pay back pay and benefits for up to 60 days. You have civil penalties of up to $500 per day, and then attorney fees and interest. So there's a lot going on there, okay? Now, just a couple things that I want you to understand about California. We have some unique features under our Cal-WARN or our mini WARN, our baby WARN. It applies to what we call covered establishments, not just the entire company, okay? It includes relocations, which the Fed WARN Act does not. The FedWarn law has exceptions for what we call unforeseeable business circumstances or faltering company, a company that is going to be going out of business. And in California, the CalWarn applies to any employee, part or full-time, who has been employed at least 6 months of the last 12, okay? Now, federal warn is different. So as I said, federal warn covers you if you have 100 plus employees. Their triggering is different in terms of job eliminations. FedWarn does not count part-time employees. They do not include relocations. And they do have those exceptions for the faltering company, the unforeseeable business circumstances, and natural disasters like floods or earthquakes. Also, the penalties under FedWarn are a lot different, okay? So what I want you to understand is when you're administering WARN and CalWarn, you often are going to have to apply provisions of both laws because some of the provisions under FedWarn are more protective of employees than CalWarn, and some of the CalWarn provisions are more protective of employees than FedWarn. So you're not going to be able to say, I'm ignoring FedWarn, okay? Now, in practice, of course, CalWarn is going to apply to more situations because it covers more employers, only 75 employees are required, and more types of events. Remember, it includes relocations. You should use the CalWarn standard when you're planning your layoffs because you're going to at least be able to meet the federal WARN timing requirements. You will have to do a different notice for them because the recipient list for CalWarn is different than for FedWarn. And just remember, they don't preempt each other. CalWarn does not preempt FedWarn or vice versa. You can be liable under both statutes. So when you are doing a layoff, you're going to want to look at both the CalWarn and the FedWarn to make sure you're doing what you need to be doing. When in doubt, just provide the notice, right? Because the penalties, particularly in California, can be so steep. You're going to want to keep all your written documentation of, the number and type of affected employees, meaning part-time or full-time, the reason for the layoff or the closure or the relocation, and copies of the notices that you send. And of course, you're also going to want to make sure that you review your local and industry-specific rules. Okay, now back to the new law. You needed that sort of overview so I can explain to you what's going on with SB 617. Okay, SB 617 expands CalWarn, okay? And it adds some really important content and coordination requirements. So under 617, you have to provide very specific information in your 60-day notice, okay? You have to include now whether you plan to coordinate services for employees through the local workforce development board or another entity or no entity at all. So you have to say, like, are you going to use the LWDB, the local workforce development board, or the EDD to try to get some services to your employees or not? And even if you decide you're not going to coordinate, you have to include the email and phone number for the relevant LWDB, the Labor Workforce Development Board. And then you also have to include a required statement, okay? And this is in the legislation in SB 617. Local workforce development boards and their partners help laid-off workers find new jobs. Please visit an America's Job Center of California location near you. You can get help with your resume, practice interviewing, search for jobs, and more. You can also learn about training programs to help start a new career. Okay, that's the quote that has to be in the notice. Now, another requirement of SB 617 is you have to include CalFresh, which is California's statewide food assistance program, in every CalWarn notice. So you have to include a short description of what CalFresh is. You have to give them access and information to access the CalFresh Benefits Helpline, and you have to give them a link to the CalFresh website. So again, as I said last week, when you're using template documents, you have to be sure you update them. So these are very important updates for your WARN notices and your CalWarn notices. And of course, the purpose of including the CalFresh information is to make sure that any displaced employees are aware of the public assistance that may be available to them. There's also a requirement that each notice has to include an actual employer email and telephone number that people can access. I know this seems like, okay, duh, don't we already do that? No, many of you don't, right? You just give the notice, but you actually have to have an email and a telephone number that is monitored. It cannot be some, number or email that just goes out into the oblivion and no one ever checks it. Number 4, if you decide you're going to coordinate benefits through a local workforce development board or another entity, you have to arrange them within 30 days. That means you have to plan what we call rapid response sessions early on in the process. And the rapid response sessions are the resources and the meetings that the EDD will provide and the local workforce development board will provide to help your affected employees. But you've got to plan ahead because you've got to do that within 30 days. Remember, you're only giving 60 days notice. As I mentioned, the new law is effective on January 1, 2026. So that's important. Just remember that when you're talking about Cal Warren, as I mentioned earlier, it's going to apply when there's a plant closure that affects any number of employees, a layoff of 50 or more employees within a 30-day period, regardless of the percentage of the workforce. Fed Warren looks at percentage of the workforce. And then there's that relocation of at least 100 miles away that affects any number of employees. So Cal Warren is much more broad in its protection than Fed Warren is. So remember, SB 617 does not change when Cal Warren applies, but it does change how you are going to be communicating with employees, okay? And also with the local workforce development boards and any other agencies like the EDD who you might be contacting to help coordinate services. So there's a lot going on here in terms of layoffs. One of the things we haven't talked about yet, of course, is when you are deciding which positions are affected, when you need to do some kind of a restructure, you got to be fair. You got to be objective. I literally had someone call me a couple of weeks ago and say, Jen, we're going to do a layoff, but I've already figured out where 40 of the 50 people are coming from because they're all on leave. Okay, can you believe that? So the person's like, well, yeah, it makes sense to me. And by the way, I get it. It's logical. They're already outside of the workplace. Why don't we just let them be affected? Let's take care of the 40 that way. And then we'll only have to lay off 10 people who thought they had a job to go to every day, right? Those people on leave know they're not coming to work every day. It doesn't work that way. You can never take into account their leave status when you're making a decision about who's going to be affected by a layoff or any other workplace decision. So be very, very clear when you are doing your analysis. How are you choosing? Easiest way to choose, of course, is by tenure, seniority. How long has somebody been with you? How long have they been in their role? That's easy, but you know what that often does? Doesn't let you keep the new good employees who you love, right? I love it when we get new employees in our firm because they bring a new perspective. They bring value. They have new ideas. They're going to be the ones who get the boot if you decide that you're going to go by seniority. Now, you may decide that you either have to do that because you're a union workplace or you want to do that because it's less risk. That's fine. I get that. But if you don't go with an objective seniority type based process, you have to be able to show how you made your decision. Are you ranking people? Are you getting feedback from others? What are you doing? And are you following whatever procedure you come up with? The worst thing you can do is come up with a procedure that you don't follow. Okay, that is just not going to fly. So if you come up with a way to determine which positions are affected and then you violate it left, right, and center, you're going to have a problem. Okay, so this is nothing to rush. This is nothing you want to do on the fly. You need to take some time to really think about what are we doing and how are we doing it? And obviously, SB 617 requires that you've got your ducks in a row in terms of those notices that you're going to be providing. Everyone, thank you so much for joining me here today. I hope you're having a lovely holiday season. Go out and do something nice for someone. Keep up the good work, and I will see you on New Year's Eve. Before we sign off, I want to remind you about our 25th annual legal update. We have 3 sessions. I want to make sure that you sign up for them before they fill up. We're going to talk about all the new statutes for 2026 and all the relevant court decisions, as well as any other agency developments. So go to our website, sign up, space is limited. Workplace Wake Up, including our guests and hosts, do not provide legal advice in this podcast. Do not act upon any of the information discussed in this podcast without first consulting a licensed attorney in your jurisdiction. Thank you for joining me on this episode of Workplace Wake Up. If you found today's discussion helpful, be sure to subscribe, leave a review, and share the podcast with your HR and leadership teams. For more insights, training programs, and legal updates, you can visit us at shawlawgroup.com.